Today's webinar is entitled COVID-19 Travel Disruptions, Impact on Foreign Business Travelers, Executives, and Their Employers, and is brought to you by the European American Chamber of Commerce, where Europeans and Americans connect to do business. I'm Todd Schwartz, Executive Director of the EACC chapter of Greater Cincinnati, and I'll be your host today. Now, we have over 120 registrants for today's event from as far away as Australia, so I'm sure that we'll have a vibrant transatlantic and international discussion. One quick disclaimer. Please note that all comments and opinions presented by our speakers today are their own and do not necessarily represent the views of the European American Chamber of Commerce or of its members. And now let me introduce Christina Schlesinska. She is the Executive Director of the Miami chapter of the EACC, and I'll let her introduce our topic and our speakers. Christina, over to you.
Thank you, Todd. Good morning, good afternoon, or good evening for those of us listening all the way from Australia or South Korea. I'm delighted to welcome you to this program, which is part of a series of webinars on cutting-edge insights and information, which the EACC is putting together for you to better navigate today's troubled COVID-19 waters. This program is organized by EACC Florida, together with EACC New York and its Executive Director, Yvonne Bendiger-Rothschild, and a little bit of help from EACC Cincinnati. And we'll discuss some of the taxation and immigration issues confronting executives, business travelers, and employers on either side of the Atlantic resulting from the COVID-19 travel disruptions. Our speakers for the day are Curtis Best, who is Managing Director in Andersen Tax New York office and who will be our moderator for the day. Scott Bettridge is a partner at Cozen O'Connor and chair of Cozen O'Connor's immigration practice. Scott joins us from Cozen's office in Miami. David Roberts is also managing director in Andersen's tax office in New York. David qualified as a tax professional in the United Kingdom and has worked with international clients in Europe, Asia, and the United States. Jose Suarez is a partner with Spanish law firm Perez Yorca's tax team in Madrid and leads the firm's private client practice. Jose will be providing us with insights into the situation in Europe. You can find full bios in the EACC Florida website. And now, with no further ado, Curtis, the floor is yours.
Thank you, Christina. Let me get the slides up. All right, 2020. I don't think we saw this coming. Oh my, the COVID-19 emergency. Governments have been shutting down economies, borders have been closed, flights canceled, transportation disrupted, you got shelter-in-place orders, quarantines, and many just feel unsafe traveling during this emergency period, even if they can. Collectively, these are the COVID-19 emergency travel disruptions. And what's a stranded traveler to do? They're going to be subject to tax where they're stranded. And what about immigration status? Well, today we're going to cover tax from a US and an EU perspective and immigration from a US perspective. So let's start with the US and an individual perspective. We'll turn it over to Dave Roberts. Dave?
Thanks, Curtis. Could you move to the next slide, please? Thank you. So I'm going to spend a few minutes just covering the impact on individuals from a US perspective. And as I go through this, I'm going to cover two core topics. One is, will the amount of time spent in the US cause any residency issues? And secondly, if somebody is spending time in the US, will it cause any tax issues as a result of it? So, and then we'll switch then back to from the employer perspective back to Curtis afterwards. So if you could go to the next slide, please, Curtis. So what is kind of the baseline? A lot of people who come to work in the US are quite conscious of the amount of time they can spend in the US without becoming a resident. But just a quick refresher on what those actually mean. A US tax resident is somebody who's either a citizen or green card holder. But then there's also a days test, which is relevant to this discussion. And that days test is essentially somebody spends up to 183 days when you look back over a 3-year period and you count the current days, and then if you also add in 1/3 of the prior year days and 1/6 of the second prior year days, if that totals 183 days or more, you are potentially a resident of the United States. This is called the substantial presence test. As the name implies, it's based on substantial presence. The reason I say potentially a resident is because there are some exceptions. And one of the key exceptions is that if you have a closer connection to another country, that even if you fail this test, as long as you're less than 183 days in the current year, you can still claim that you're not a resident of the US because you maintain closer ties with the country. So a simple example would be somebody who spends 150 days on average a year would be less than 183 in the current year, but this formula would take them over the 183 and would cause them to be a resident. But because they're only spending 150 days here, they're probably spending 200 days in another country, and it'd be easy to establish that they have a closer connection elsewhere. So under that exception, even if you go over this test, you can still argue that you're not a resident. The other relevant issue is what we call the medical condition exception. This wasn't widely used prior to COVID-19, but basically the medical condition was for somebody who came to the US without a pre-existing medical condition and couldn't leave the US because of that condition, and would essentially would not count those days towards their test. The simple example of that is business trip, gets hit by a taxi, unanticipated, gets stuck in hospital, has to spend time here and can't leave. So those days would be exempted. And then the final thing to consider when you're looking at residency is that if somebody is actually in the US more than 183 days in the current year, then they are a resident, but certain treaties that are in existence have what we call tiebreaker provisions, that if somebody is also a resident of another country as well, they can look at certain factors and they can claim they're not a resident under a treaty. So you can go to the next slide, please, Curtis. So with that in mind, what the potential risk for a lot of people in the US was, am I going to trigger these days test that's going to cause me to be a US? Or even if I go over days where I now have to file a tax return and claim not to be a resident under closer connection or some other means. So the IRS responded to it with what this revenue procedure 2020-20. And what they did with that is that they acknowledged that there's going to be people that are stuck in the US, not necessarily because of a medical condition due to COVID, but because of the associated travel disruptions. So what they introduced was a period, and they allowed that an individual who is in the US, who can't leave the US, want to leave the US because of health risks, can exclude up to 60 days if they arrive in the US within a period of time. And that period is from February 1st to April 1st. Now they can choose the 60-day period during that period as well to exclude. So if you think of a quick example, somebody who actually arrived in the US at the end of March, right before the end of this period, they could exclude the next 60 days out until almost the end of May as being their period of exception if they wanted to not count those days. I had an inquiry recently where somebody was from Bermuda and they didn't arrive into the US until April 7th, but because of the island, it was shut down, the airport was closed in Bermuda and they were unable to leave. So in that situation, that's just a case of tough luck right now. They just came in too late. They weren't part of this emergency period. They arrived in the US after it and they couldn't still go back. So we do expect there might be some more guidance from the IRS in those particular situations as this. So the bottom line is, as regards residency, the IRS has given people a break. They can exclude up to 60 days. Who knows if this thing continues and we have second waves and everything, this may change again. So what does somebody do to prove that? Well, they're filing this under the medical condition exception, which I referenced earlier. And under that exception, that form is modified to basically, it's called the form 8843 and would be filed. And under that form, you'd select the 60 days they were excluding, and that would determine your residency status as a non-resident. So residency is determined on the days. As I mentioned, you can exclude those 60 days. What about the income side of things? Well, if somebody's in the US working and they're performing services, It's what we refer to as effectively connected income. Now, it could be for an employer, it could be for a partnership of their own, or an entity that they're dealing with. If somebody is here working, if they're having to perform services that they wouldn't otherwise have considered performing in the US, those services can also be excluded during this 60-day period. So the IRS issued a number of what we call frequent FAQs, frequently asked questions, that try to address some of the things. And in typical IRS guidance, these are not as clear as we'd all like them to be. But essentially, what they did do is say that if you have a non-resident who is in the US for the exemption period of 60 days, they can exclude the income that is associated with those days from being US source income for purposes of filing taxes. The final thing I want to mention is regarding treaty exemption, because most treaties, and a lot of people who come to work in the US are familiar with the treaties that come from treaty countries. And essentially, most treaties say that if you're in the US for less than 183 days, and if you're paid by an entity, and you actually, those costs are not borne by a US entity, that you can exclude from US income. And the final thing that they did in this Rev Proc that they introduced was they said that if you fail the 183-day test by virtue of going over, that they'll also exclude those days for purpose of the treaty. So somebody who goes over fails that 183-day test can also exclude the days under this test. So in summary, Curtis, the IRS has been very generous. It's given a 60-day exemption from both days and in most cases from income due to COVID. I think we'll see more guidance come out over the next few months as we deal with the ever-changing landscape that we're dealing with. But this covers it purely from the individual point of view. But I'll switch it back to Curtis, who can talk more from the corporate side of the house.
Thank you, David. And I'm going to cover the commercial aspects. And first, let's talk about the implications absent any relief. Okay. And I'm going to go ahead and define an effective person. An effective person is a non-resident alien, a foreign corporation, or partnership in which either is a partner. And it includes a controlled foreign corporation, or CFC, which is a foreign corporation that's owned greater than 50% voter value by US shareholders. Okay. So effective persons who employ individuals or agents to perform services or other activities in the US may be considered to be engaged in a US trade or business absent any relief. If these individuals are performing these services and activities while they're temporarily in the US during the emergency travel disruptions, okay, they may be subject to tax on their business profits, or ECI. If the US income tax treaty applies, typically you're not liable for tax unless the business is conducted through a permanent establishment in the US, such as an office, a fixed base, or dependent agent. So now let's look at the IRS relief that they've issued for businesses in the form of 2 FAQs and some general information. So FAQ 1, will a non-resident alien or foreign corporation not otherwise engaged in a US trade or business be treated as engaged in a US trade or business as a result of services and other activities conducted by one or more individuals temporarily present in the US if, but for COVID-19 emergency travel disruptions, those services or other activities would not have been conducted in the US. Now, this is very similar, as David explained earlier, for individuals, for effective persons. You get to choose an uninterrupted period of 60 days, beginning on or after February 1, 2020, and on or before April 1, 2020. If you are in the US show up on April 2nd, it doesn't apply, okay? But that does cover a period, depending on when you select your emergency period, between February 1st and May 31st. Again, provided though these activities would not have been conducted in the US except for the emergency travel disruptions. FAQ 2, if a non-resident alien or foreign corporation is engaged in a US trade or business, but otherwise does not carry on such US trade or business through a permanent establishment, PE, under an applicable income tax treaty, will the non-resident alien or foreign corporation be treated as conducting business through a PE due to services or other activities conducted by individuals temporarily present in the US that would not have been conducted in the U.S. but for the COVID-19 emergency travel disruptions. Well, this is just taking FAQ1 and extending it a little bit further and saying that affected persons' activities will not arise to the level to create a PE, okay, during the emergency period, provided they would not have been conducted in the U.S. but for the emergency travel disruptions. And let's look at now the general information. Affected persons' income will not be taxed in the U.S., particularly not the 30% gross basis tax, solely because the affected person is not treated as having a U.S. trade or business or PE under these FAQs. However, there are contemporaneous documentation requirements, okay? One, you need to establish the period chosen as the emergency period. Second, needs to be established that the business activities conducted would not have been conducted in the U.S. but for the emergency travel disruptions. And this documentation must be available and provided upon the request of the IRS. And what does this documentation look like? Well, canceled airline tickets or other travel arrangements, statement from employees that they just felt unsafe to travel and documenting why, even if they could have traveled. Quarantine orders, shelter-in-place orders, border closing information. You know, any information that you can use to document the travel disruptions. Now, affected persons, however, still can file a protective tax return in the U.S., even if they believe they're not required to file. This will avail themselves of benefits and protections that arise from those filings, such as deductions against gross income, getting the statutes of limitations running, and claiming tax treaty-based relief, okay? That kind of rounds out the US side from an individual and a commercial. But what about the EU? I'll turn it over to Jose now. Jose?
Yeah, thank you so much, Curtis and David. Well, first idea that I think that we need to take into consideration is that even though Europe is big in terms of population, it is scattered into numerous small states. So just in the EU, we have 27 states that have their own direct taxation rules because they are not harmonized at the level of the EU. So these two concerns that David was pointing out, which is tax residency and also potential to have income subject to taxation, should be analyzed in each country. So the resolution of the question could vary from one country to another. So tax residency is a legal term, and as such has to be defined and analyzed under the rules of each state. So basically, this means that the specific circumstances of this stranded individual and the corporation for which he or she is working has to be analyzed in light of that, in those rules and that regulations. So, yeah, mainly, how can the COVID emergency affect people here and individuals? Well, it can affect to the number of days that a person stays in a country, or it can also affect if this person has an habitual abode in another country. So this tax residency aspect has to be analyzed under the domestic regulations, and these regulations take into account aspects such as the existence of a permanent home, the social and family ties of that person, the number of days stayed there, citizenship, the permanent residency. So that is what has to be taken into consideration in order to determine if the stranded individual has to be considered as a tax resident in that country for domestic purposes. Then, if there is an applicable double taxation treaty, which is a bilateral treaty signed between the country of stay and the country of usual residence of this person, then it will have to be analyzed if that treaty is applicable, and in that case, what the outcome of those rules are. Yeah, so the emergency can affect, as I said earlier, to the number of days a person stays in a country, or to the fact that he or she has a resident, even if temporary. So, I mean, there are some aspects that have to be taken into consideration in relation to these two aspects. In relation to number of days abroad, we have to take into consideration the period of reference to which the count is carried out. That can be the current natural year, or that can even be subsequent years, such as was the case in the US regulations that we have just reviewed. Then we also have the thresholds, which would be different in each state. And as you can see here in this slide, we can have from like 30 days to 90, 6 months, half a year, 183 days, 280 days. I mean, there are very different scenarios depending on the country. And then we also have to determine how these time lapses are computed. They can either be broken or unbroken. So that's why the outcome can vary from country to country. There are some countries also that have some specific rules to avoid spurious changes in tax residence, such as could be the case of Austria. This is in the next slide. Sorry, Curtis. That can be the case of Austria, for example, Greece, that has like a medical condition exemption, kind of similar to the US that we have just reviewed, and also the case of Spain, where the country relinquishes the possibility to tax that individual if he can evidence another tax residency. We can also point out the case of Romania, where by means of administration resolution, the tax residency is determined. It is also important to note that tax residency can not only affect the personal income tax, but also other taxes. So it is important to carry out a proper analysis and a thorough analysis of the specific case of the individual. So, okay, we have an individual who may be considered as tax resident in 2 different countries. Yes, thank you for this. So next thing we need to determine is if under the applicable double taxation treaty, this person could be determined as resident in just one state. So if there is a treaty, we should go to Article 4, which has usually contains the tiebreaker tests, which are reviewed in an order of preference, just as listed here in the slide. So as you can see, the number of days is in 3rd place. So if we can evidence that this person has a permanent home, not in this country, but in his home country, or his center or her center of vital interest is not in the country of stay, then we should be more or less comfortable with that, and that person should not be regarded as resident in that country. The view of the OECD Secretariat, as expressed in April 2020, is that in case of treaty residence position, the COVID situation should not alter the residence of individuals. But the thing is that even if the most of the people or the individuals who are traveling across Europe and the US may come from a country that has a double taxation treaty in place, that may not be the case. So in that case, we could have double taxation, and we would need to review the domestic regulations of each country to see if there is some kind of relief for that double taxation. It is also important to take caution for subsequent trips to the country of stay, because it is quite likely that the tax authorities will rely on a good faith approach in relation to determining the tax residency of individuals. So we have to take into consideration the thresholds, the specific rules. For example, if that country has a look-back approach in regards to determining the number of days that a person has stayed there. So I would say that we would need to take more caution in the future. So if a person is not determined or is not deemed as tax resident in the country of stay, that does not mean that he will not be taxed. I mean, if he were determined as tax resident, he would be taxed on his worldwide income and probably also on his wealth and some other taxable events, possibly. But the thing is that even if he's not a tax resident in this country, if there is some kind of income which is sourced from the country of stay, then this person could be taxed in this country. There is no one solution for all the cases, so one size does not fit all. So we will need to take a case-by-case approach. But it is true that there are two generally accepted rules contained in the double taxation treaties, which is that labor income could be taxed in the country of stay in case the individual stays over 183 days in a year, and the expense is borne by a corporation which is tax resident in the country of stay. So if we have taxation in the country of stay, then we will also need to take a look at the domestic regulations of the home country to see if there's some kind of double taxation relief mechanisms available. So this brings us to corporations. Also here we have to analyze those two main aspects, which is tax residency and the potential to have income taxed in this country of stay. So tax residency, again, is defined under the domestic regulations of each country. And there are mainly three aspects which are taken into account for determining the tax residency, which is the place of registration or incorporation, the place where main and substantial activity is carried on, and lastly, the place where the corporation is effectively managed. This last aspect, the effective management, is the most important aspect, not only in domestic regulations, but also in the double taxation treaties. So on the next slide, we have some sort of definition or of effective management. This is a factual concept, and it is usually determined in light of some of the following circumstances, which relate to strategic decisions, where the general meeting is usually held, where the board of directors usually carries out its role and its tasks. So we can see that in principle, the travel disruptions should not clearly affect the tax residence of a corporation, because it is quite likely that the books and the records, for example, would be kept in the same place, or the AGM would meet in the same place, and not all the directors would be affected by these travel disruptions. So that is why in the next slide, we have the view of the OECD Secretariat, where it is also stated that it is unlikely that the tax residency of corporations could be affected, mainly because the effective management has to be analyzed in relation to ordinary situations or usual circumstances. So the fact that in this case, companies may have individuals abroad, or that part of the business is carried out abroad, should not affect the outcome of the tax residence test. In the next slide, we have more detail in relation to permanent establishments, which could also be applicable to the case of tax residency. So if a company that does not change its tax residency, then we should also question ourselves if the presence of these stranded individuals in another country could create a permanent establishment in that country. Basically, a permanent establishment is like an ideal corporation that only exists for tax purposes, to which a part of the entrepreneurial income is allocated just for the purposes of being taxed in that country. So for this permanent establishment to exist, the company needs to have a certain degree of presence in the country. So usually, I mean, there are three main aspects which are taken into account, which, for example, the case of works, but I mean, the COVID emergency should not make a work permanent establishment cease to exist. And then we also have the use of premises and the use of dependent agents in countries. The thing is that in relation to these two last aspects, what the tax treaties require is that this use of premises or the use of dependent agents is habitual. So in this case where we are dealing with an emergency situation and mostly in force majeure causes, it is quite difficult to sustain that the way in which the company usually carries out business has changed. So we also share the view of the OECD Secretariat that no PE, no permanent establishment should exist, should appear, or should cease to exist, mainly due to the COVID emergency. So, and then in relation to the next slide, it is also important to note that both in relation to individuals and corporations, some tax authorities have issued guidelines, such as the case of the US, where we were just reviewing those new regulations. This is the case of Ireland, UK, and Australia. In this case, out of Europe. Maybe some other administrations will issue new guidelines, which I think should be quite desirable, just to have the taxpayers and the individuals feel more safely in relation to their tax residency. So now it's the turn of Scott to give us an overview of the immigration implications.
Excellent. Thank you, Jose. I appreciate it. Yeah, so let's jump to immigration. Obviously, currently it's been a fairly challenging and difficult immigration landscape, probably unlike anything we've seen in the past number of years, even surpassing the impact of after 9/11. Since mid-March, up until June 4th, the USCIS offices in the US were closed. They were not holding appointments. They continued to process applications. They certainly continued to process cases that were filed locally. But consulates and embassies overseas were not open to visa processing. They had been open only for emergency services, services to US citizens, but not visas. So we've definitely faced a challenging time for individuals that have been stranded outside the US, both on a personal business travel, as well as work and employment authorization scenarios where they've been stuck because they can't have an appointment, a visa appointment to process for their employment application. So one of the things I wanted to cover was, what if I'm in the US right now and I'm here under whatever status, and whether that's work authorized or even as a visitor, what am I to do if I can't travel and I can't depart the US before my authorized period of stay expires? Well, the one simple answer is you must do something. You want to be always able to maintain lawful status in the US. You do not want to expire. Now, what that answer may be can include filing an extension of your status. So certainly if your employment capacity or even as a visitor status, you may decide to extend that because you can't travel. So you would file that application with the Immigration Service. You may decide that you are eligible for a green card or permanent residence, where in the past maybe you had a qualifying relative or a qualifying opportunity to process and you've never undertaken that process before, but now you say, listen, I'm here, I'm stuck, I might as well wait it out and file for that application now. You can change status. I've had a lot of individuals, unfortunately, who have been dealing with layoffs and furloughs, who have decided to enroll back in school. They're not in a position where they can depart the US and go back home, if you will. So they're looking to change their status. They enroll in a degree program here to at least be lawful and legal, and to maintain the lawful status that they have. One of the bigger keys and one of the questions that comes up quite often is what's called satisfactory departure, and that's for ESTA individuals. ESTA is also commonly known to as the Visa Waiver Program. Those of you that don't know, the Visa Waiver Program enables nationals of 39 different countries to travel to the US for business, for tourism, and be able to stay for up to 90 days without requiring a visa. It's very similar. U.S. citizens have very similar reciprocal programs to other countries, specifically in the European Union. Visa waiver program travelers generally are not eligible to extend their stay. It's you depart on day 89, or if you overstay your ESTA entry, you are subject to being disqualified from using ESTA ever again. You could so if you overstayed ESTA, you wouldn't be able to use that program in the future. However, those folks that are here now, if you're expiring on that 90-day period of ESTA, satisfactory departure is available. And what this is it's a new program, not say a new program, but it's something that had not been utilized that often. It allowed individuals to apply for satisfactory departure before their period of authorized stay expires. Grants of this extension basically give ESTA travelers an additional 30 days to remain in the U.S. lawfully and legally. Again, focused on those individuals who are experiencing difficulty returning to their home country, whether that's travel restrictions, flight cancellations. It used to be utilized mainly for those that suffered illness in the U.S., but now we're seeing that being applied across the board. So satisfactory departure, you can go to your local CBP port of entry, deferred inspection sites. You can go to the local USCIS office now that they're back open, and you would ask for satisfactory departure. So I think that's been a very helpful scenario. Again, the key here is do not let your status expire. Always maintain lawful capacity in the U.S. So if you are stuck in the U.S., what can you do? You're here as a business visitor, as we were talking about before. Forget about the tax consequences for a moment, but what are you authorized? What are you able to do? Bottom line is that if you're here as a business visitor, you are not authorized to provide what they call productive services to a U.S. employer. What are productive services? Well, that's anything that would benefit, the benefit of the individual's time accruing to a U.S. employer. A great example that the Immigration Service gives is individuals that are coming to the U.S. as a trainee to undertake training in the U.S. can do so properly as a business visitor. They can come to the U.S., they can accept that training with the intent of departing the U.S. and imparting what they've learned in that training to their home country employment and part of their work for their foreign employer. Contrast that with coming into the U.S. to be a trainer, to train U.S. workers. Well, that is defined as productive service. The benefit of that training is left with the U.S. employer, and you cannot lawfully do that as a business visitor. You need to be able to obtain a work visa, an employment visa, to come and provide that productive services to the U.S. Generally, as a visitor, you're here for a short period of time, a limited specific period of time. You've got proper funds to cover that period so that you're going to be able to cover your expenses. You're admissible to the U.S. You have a residence abroad of which you have no intention of abandoning. You have an employer abroad. And the purpose of your trip is to enter the U.S. for a legitimate business, temporary business visit. You cannot be paid in the U.S. You cannot have a business card. You cannot have an office. You can go to your office, but you cannot have your own physical office in the U.S. I think one of the other things is to a question that comes up often are individuals that say, well, I'm the global CEO, I'm the global CFO. Yes, while the time of my travels to the U.S. are temporary in nature, and there are on behalf of my role with my foreign employer, they are also going to impact the U.S. business and affect the U.S. business while I'm in the U.S. because I have a global role. Well, that's deemed to have been okay. Immigration has said that so long as you're benefiting the foreign entity, any ancillary benefit to the U.S., so long as the foreign entity is served, that certainly is lawful and legal. About working from home in the U.S. for a foreign employer, this comes up quite often for individuals that are here as the spouse of someone that's on an employment visa, someone who's here maybe going to school. The question as to whether you can work from home, work in the U.S. for a non-U.S. employer is a question, very germane question based on what we've been dealing with David and Curtis and Jose in terms of it lies squarely at the intersection, I believe, of immigration and tax. The short answer to me is no. You cannot work for a foreign employer from the United States. As discussed before, any income from services performed for a foreign employer by someone present in the U.S. can be deemed to be U.S. sourced income. There are those three exceptions that exist. The ramifications for the foreign employer, I would say, are much more significant and involve, as we discussed, overlapping issues of global mobility, tax, immigration, corporate employment laws. It's definitely something to be concerned about, but I definitely fall, I'd say unequivocally, on the unauthorized employment scenario. And again, the salary that's paid for the employment is active earned income. And someone in the U.S. is they're not here for a brief or intermittent period of time, so that they should not be authorized to work from home for a U.S. employer. So many of you have read about the travel bans, even as late as maybe 2 weeks ago. The Trump administration announced the expansion of the COVID-19 travel bans to include Brazil. So I just wanted to make sure we have a tremendous amount of questions that come up about travel bans. Oh, I'm Brazilian. Does that mean I can't come to the U.S.? What are my restrictions? Well, Brazil just joins a long list of countries that already are subject to similar travel bans. China, Iran, the European Schengen area, the UK, Ireland. All these countries, based on the COVID numbers, have encountered these travel bans. The new proclamation with Brazil bars all non-US citizens who have been physically present in Brazil during the 14-day period prior to entering or attempting to enter the U.S. Now, I know that there was a question before. This doesn't mean it just bars Brazilian citizens, or that it would not apply to Schengen area citizens attempting to enter the U.S. after spending 2 weeks in a non-barred country. So, in other words, an Australian coming to the U.S. directly from Brazil would be barred, but a Brazilian coming to the U.S. after 14 days in Australia would not be barred. So while these restrictions are being looked upon to be relaxed at some point in the very near future, right now they certainly are in place. There are exceptions to these. Clearly, they don't apply to U.S. citizens. They don't apply to U.S. green card holders, their spouses, their dependents. But mainly this seeks to bar individuals that would be coming on, whether that's a visitor visa, B1, B2, L1s, H1s, other types of work authorized status. That's one of the bigger things that we're seeing that impacts employers. Hopefully they will be cut back soon as the levels and impacts of COVID decrease, but rolled back. But right now they're still impacting employers and employees alike. So I just wanted to raise one point just about the previous proclamation back in April. The president issued a proclamation suspending the entry of immigrants who present risk to the U.S. labor market during the economic recovery. Certainly this was an issue. It impacted individuals who were waiting for immigrant visas abroad, certain family-based applications of U.S. citizens and residents, employment-based applicants, diversity visa applicants. There was a handful of exemptions as well that existed for immediate relatives of U.S. citizens, EB-5 investors it didn't cover, adjustment of status applications. These were individuals who were processing for a green card at a U.S. consulate or embassy abroad. It seemed significant, and there was a lot of issues in terms of, wow, I can't process any further. In reality, based on all the restrictions, it only impacted, I would probably say, anywhere between 20 to 25% of all applications globally. Obviously, this was in response to the higher unemployment rates that we're seeing across the U.S. I fully believe that there are additional changes on the horizon, which could come as soon as the next week or two, with respect to limitations not just on immigrant visas, which are green cards, but what we call non-immigrant visas, which are those work authorized visas, H-1B, L-1, which could potentially be limited. Again, this is all to protect the U.S. labor market, protecting the jobs of U.S. workers, theoretically. And I think that we're going to see some changes as it results to perhaps F1 OPT. There are foreign students in the U.S. are allowed to work for a year without sponsorship. They can work in their field of study post-degree. That's something that may be limited, as well as perhaps L2 and E2 spousal work authorization, H4 spousal work authorization, things that are, there's been discussions that they were going to limit H1Bs altogether. I think some of those issues, if they come to that, are ripe for litigation, but certainly there is a desire to try to modify the immigration laws in the short term to try to protect the U.S. labor market. You know, there's a handful of other things that I can provide to you folks. I think there's an FAQ that I have. It's about 6, 7, 8 pages long. I'm happy to share that with anyone that discusses layoffs and furloughs. We just don't have enough time to cover all these types of issues right now. Material changes to individuals who were authorized to be employed but now have been sheltering in place or working from home. Are there terms and conditions of changes to the current visa? Payroll's been reduced, hours have been reduced, travel issues about going to U.S. consulates abroad, et cetera. So certainly if anybody has any questions with respect to that, you can reach out to Todd, Christina, and myself, and I can share the FAQ with you. I know we want to spend some time looking at answering any questions anybody had. I can throw it back to Curtis or to Todd to start reviewing those.
So we have 4 questions. I hope that we have time to answer them all. So I think that there's been a question which has partly been answered already. If coming from Europe prior to returning to the US, we do a 14-day vacation in a non-banned country such as Mexico, Qatar, or a non-Schengen European country such as Croatia or Cyprus, are we allowed to enter with no risk? I think this is a question for Scott.
Yeah, I mean, I think the issue is that, you know, so long as you're not you haven't been physically present in one of the barred countries in the last 14 days, you should be eligible to enter without risk. I see additional questions talking about that individuals were advised to said that U.S. CBP officers were against that idea because you're looking at a way to circumvent. The idea is not a matter of circumventing issues or finding a loophole, if you will, in U.S. immigration policy. I believe that it's from a public safety and health issue. So as long as you're spending you're not in the last 14 days, you're not in any of those restricted countries. I have many employers who routinely in the last 2 months have been sending individuals to a third country, not just so much to go spend the 2 weeks on the beach and relax, but they're going to these third countries to go and actually be employed temporarily, if you will. I've had them go to the Bahamas, some go to Canada, wherever their opportunities exist from an employment perspective. They're waiting out that 2 weeks. Maybe it's not on day 14 and a half, day 15 that they're coming in, but certainly they're not experiencing any problems, and I've not had any problems with employees specifically looking at this as a problem. I see that there's another question, regarding E2 visas to green card. Yeah, I mean, I think the E2 to a green card, those cases are still being processed. The issue, I think, when we look at the notion by the administration to protect U.S. jobs, I think that the more narrow focus of that really is with respect to individuals that have the ability to work as a free agent, if you will, that don't have any restrictions to the terms and conditions of their employment. So not so much as an employee that's being sponsored by an entity that treats somebody as an international manager or executive coming to the United States, someone that has specialized knowledge to the United States, someone that has is a professional specialty occupation, meaning they have a degree that's related to a job and that's being offered to them. There's not a process that's limiting green cards. What I do think will be challenging for employers is simply the issue of there's sometimes what employers process what's called PERM or labor certification, and which requires that the employer tests the U.S. labor market to show that there's no qualified, willing, or able U.S. workers that can fill that job. I think that's going to be challenging, especially when they have to show that you're cross-referencing job banks in each state. You're cross-referencing resumes and CVs that are received in response to those recruitment efforts. That's going to be challenging. But right now, E2 to a green card is still possible. People are filing green card applications every day. I think this is short term is the issue, even if there are challenges to temporary non-immigrant visas, but those will be probably, if they do get put into place, probably would not even last through the end of the calendar year, in my opinion.
Thank you. I think we have a question here for Jose, and it really has to do with some of the tests that you've cited earlier in terms of keeping the records and the books and where those are located. These days, wherever we are, I mean, those books could be located in the cloud somewhere. So how would that work in terms of defining the location of the books regarding the tests that you mentioned?
That's a good question.
Need to be updated in that area?
Yeah, that's a good question. And I mean, one kind of activity that I didn't want to specifically analyze was the internet-based kind of businesses, because these businesses may be more affected by others who are more work in a more traditional way. Books, I mean, they can be drafted and done, I mean, with PC tools and so on, stored on the cloud. But in the end, these books have to be filed somewhere. For example, I mean, you may have to file the accounts, the statements with the House of Companies, and that is one key aspect that is usually reviewed in relation to this aspect for the determination of the tax residency. For example, corporations that are subject to auditing process, I mean, they need to have a country where they are registered for these purposes. So in the end, even if the files are stored anywhere, I mean, they're in a server, which is probably not in the US or even in Europe, there is some place where these books and these registers are attached to physically. So that's the evidence that will have to be reviewed, in my opinion.
Okay, I don't think we have any more questions. And anyway, we are coming to the end of this program, which was absolutely fascinating. Technical, complex, but fascinating. We had very good speakers. Thank you very much, Curtis, David, Jose, and Scott, for enlightening us with this. You're, of course, welcome to contact me if you have any questions. We will be sending out the slides after this program. And now over to Todd for the last final words.
Thanks so much, Christina, both for your support and for your hard work in putting this event together. That concludes today's webinar entitled COVID-19 Travel Disruptions, Impact on Foreign Business Travelers, Executives, and Their Employers. As Christina had said, thanks to our presenters Curtis Best, Scott Bettridge, David Roberts, and Jose Suarez for sharing your experience and insight. And thanks to all of you for joining in today's discussion. Just a reminder, all comments and opinions presented by our speakers today are their own and do not necessarily represent the views of the European American Chamber of Commerce or its members. Please stay in touch with your local chapter of the EACC for information on upcoming webinars and other events. And be sure to look for a recording of this and our other EACC webinars on our YouTube channel. Farewell.